Ever wonder where all the laws in England and Wales actually come from? You might picture this huge, complicated mess of ancient scrolls and dusty books, right? Well, what if I told you it all boils down to just one tiny number? That's it. 2. Seriously. The whole shebang, every single rule, every regulation in England and Wales, it all flows from just two fundamental sources. Just two sources. That's it. Not 100, not 1,000. And believe me, understanding the epic rivalry between these two is like having the master key to the entire English legal system. All right, so who are these two big players? Let's picture them as two competing powerhouses, right? Constantly in a tug of war, shaping the laws we live by. In one corner, you've got Parliament, and in the other corner, the courts. Okay, so Parliament, they're the ones creating brand new laws from scratch. We call these statutes or legislation. They are, for all intents and purposes, the modern rule makers. Then you've got the courts. They do things differently. They build the law up, piece by piece, case by case, creating what we call common law. They're kind of like the ancient rule interpreters. So one writes the playbook, the other decides what the plays mean. Let's dive into our first contender. All right, first up in the ring, with the full force of the democratic vote behind it, is Parliament. In the UK system, when it comes to making law, you have to understand that Parliament is the undisputed, undefeated heavyweight champion. And it has this incredible superpower. And that superpower has a name. Parliamentary sovereignty. This idea is the absolute bedrock of the UK Constitution. And what does it mean? Well, it basically means Parliament can do whatever it wants. Seriously, it can make any law about any subject, and here's the kicker, no one can legally challenge it. So this legal genius, A.V. Dicey, he broke this whole concept down into two simple parts, or limbs. First, you've got the positive limb. Super simple. Parliament can make any law it feels like. But then, you've got the negative limb. And this, my friends, is the real knockout punch. No one, and I mean no one, not even the highest judge in the land, can stand up and say a law passed by Parliament is invalid. Okay, but hold on. Is that power really absolute in the 21st century? Well, it's gotten a little complicated. For years, when the UK was part of the EU, European law could actually override UK law in certain areas. Then you've got the Human Rights Act 1998, which is a big deal. It lets our courts flag laws that clash with our basic human rights. That's a pretty powerful check. And on top of that, we've got devolution, where Scotland and Wales have their own parliaments making their own laws. So yeah, the champs had a few tough challengers in recent years. All right, let's turn to our other power source, the courts. Now, if Parliament's power is all modern and shiny, built on democracy, the court's authority is, well, it's ancient. We're talking about something forged in the fires of 1,000 years of history. And this is where we get what's called common law, or as some people call it, judge-made law. See, this isn't some master plan written down in one big book. Nope, it's built up, literally brick by brick, with every single decision a judge makes in a higher court. And each of those decisions, those bricks, becomes a precedent, a solid rule that other courts down the line have to follow. And man, is it old. Just think about it. Before 1066, the law was just a total mess of local rules that changed from one village to the next. But then, after 1154, this guy, King Henry II, had a brilliant idea. He sent his judges all across the country, and their rulings started to create a single, unified legal system that was finally common to the whole kingdom. That's where the name comes from. Okay, so the stage is set. We've got the new school democratic power of Parliament up against the ancient historical authority of the courts, the ultimate rule maker versus the original rule interpreter. So what happens when these two titans finally clash, when they go head to head? Yeah, let's get specific. What happens when a brand new, crystal clear law from Parliament, a statute, directly contradicts a principle from the common law that's been around for centuries? Who wins that fight? And the answer is brutally simple. This right here is the golden rule, the ultimate, undisputed knockout punch of the entire system. Statute always prevails. It doesn't matter how old, how respected, how wise that common law rule is. If Parliament passes a law against it, the new law wins. Every single time. And boom, that brings us right back to our main event, parliamentary sovereignty. That's the reason the statute always wins. Because at the end of the day, the democratically elected parliament is seen as the ultimate source of law. And the judges, with all their history and wisdom, have to respect that. They must bow to Parliament's will.
Okay, so we figured out who makes the laws and who gets the final say. Now, let's do a quick fire round and decode the different types of law that this whole system actually spits out.
First up, public versus private law. Think of it like this. Public law is all about the relationship between you and the state. So things like constitutional law or criminal law. Private law, that's about the relationships between people or companies. Stuff like contracts, family law, you name it. Basically, one is you versus the system, and the other is you versus, say, your neighbor. And that leads us to the really big distinction you hear about all the time, criminal versus civil law. And the differences are huge. In a criminal case, you've got the state going after an individual. The whole point is punishment. And the proof? It has to be beyond a reasonable doubt. That's a super high bar. But in a civil case, it's usually one person against another. The goal isn't punishment. It's a remedy, like getting paid damages. And the proof needed is way lower, just on the balance of probabilities. You just have to show your side of the story is more likely to be true.
And just when you think you've got it all figured out, here's one final twist for you. Everything we've been talking about, it applies to the legal system of England and Wales. But the UK as a whole actually has 3 totally separate legal systems. Scotland has its own, and so does Northern Ireland, each with their own unique laws and courts. Just another little layer of complexity to keep things interesting.
So there you have it. It all comes down to 2 sources and 1 golden rule. Parliament is the supreme lawmaker, end of story, right? But you have to wonder, in our crazy, complex modern world, with all these international treaties and human rights laws, is that simple golden rule always going to be enough to settle every single fight? That's the big question.